Good evening, folks. This is the inaugural podcast for the Contested Probate website. And I have the pleasure of, having the pleasure of the company of Richard Parsons, who's a fellow solicitor in Redwood Legal. And we're going to, it's a long time since we've actually done any sort of a vlog or a podcast. I think probably the last time we did one was about 2 years ago, Richard, if you remember. Do you remember doing that video?
Yes, absolutely.
And it was actually focused on Inheritance Act claims. And it's been very popular, had a lot of hits on YouTube, and actually generated a little bit of business from it as well, been quite useful for our law firm in generating business. Now, this podcast is basically a whistle-stop tour around the bases of contested probate. And the sort of people who'd be interested in listening to this podcast are, listen up, members of the general public who perhaps are looking for a lawyer, perhaps looking for a little bit of help and advice on how to go about actually approaching a lawyer, what lawyers to use if they've got a contested probate issue. Also for litigants in person. It's a growing number of litigants in person. In fact, I think, Richard, you first produced some figures for me just a couple of years ago now, in which you said that the number of litigants in person going through the county courts in England and Wales now is absolutely quite large. Far bigger percentage represent themselves in court than use lawyers. Do you remember saying that to me? You're nodding.
Yes, I don't recall the figures, but it is the case that the number of people who are representing themselves, i.e. they don't have a lawyer, is increasing. And also law firms are having to become more flexible in the way that they deliver legal services. So they might only do a little bit of work here and there when a person needs it, rather than representing a person for 100% of everything that happens on the claim.
Yeah, I mean, that's a very interesting point. We'll come on to the issue of kind of like retainers, the way lawyers are taking instructions further on in the podcast. Now, for now, I'd like to start off by, I just should mention a third category of people who might be listening to this. That's students, maybe law students. Also lawyers who may be new to the sector and wanted to learn a little bit about litigation and in the area of contested probate. And the first thing to say, as Monsieur Parsons reminded me as I was prepping up for this podcast, is that there's a big difference between wills and probate. Like you go onto the internet and you search for wills and probate, and contested probate. Would you like to just summarise what the difference is, Richard, and why it is significant?
Yes, so I suppose we could divide our work into work that is contentious and that which is not contentious. So what we mean by contentious is one person going to court against another person. Perhaps they're arguing about whether or not a will is valid, or whether or not executors have done their role properly. Perhaps they've not declared some of the assets, or perhaps they've failed to pay some of the liabilities they should have paid, things like that. And on the other hand, we've got non-contentious wills and probate, by which we might mean something like having instructions to make a will for somebody, or after somebody has passed away, administering their estate, so winding up their affairs.
Yeah, and that difference is quite significant. We are litigation specialists. We do a little bit of non-contentious work. Predominantly, we are in the litigation game. And as will become apparent when we come on to the section on costs and retainers, it is really quite important that you find a litigation specialist if the matter is contested, if there is a dispute.
Something else that I would say about that, though, is that in circumstances where you're preparing a will, some people who are preparing a will are doing so with the knowledge that a dispute is likely. So perhaps, for example, there's a child who's considered the bad apple in the family, or maybe there's a conflict between the new wife and the stepchildren, something of that type. And in those circumstances, I I think it can be quite important to go to a solicitor who actually does have experience of contentious probate.
That's a very actually important, kind of interesting caveat that has come up actually quite a lot in another area we specialise in, which is cohabitation property disputes, where you've got a conveyance of a property and the solicitor who's actually been handling the conveyance really needs to look ahead, look in the crystal ball, and to envisage a situation in which that couple separate, and make sure it's a sort of a bit of a horrible business in many ways. Being a lawyer, you've got to look in the crystal ball and anticipate disputes and build that into the drafting. I will say though that Richard's drafting skills are pretty strong. I mean, you're actually pretty experienced drafting a lot more than I am. And perhaps my specialism is more in handling the no-win, no-fee type litigation, cost issues, and retainers and that sort of a thing. I just should explain, you'll be hearing the dulcet tones of buses trundling by. We're actually podcasting to you from Warsaw in Poland, where I have a flat, and Richard's come over with his lovely wife to enjoy a little bit of my hospitality, a little bit of Polish hospitality. So forgive the motoring interruptions, if you will. It's hard enough finding time to litigate our cases, let alone produce podcasts and vlogs for our websites and our YouTube channel. Okay, so for those of you who want to know what's coming up, we're going to talk firstly about heads of claims. I like to think of heads of claims as the gateway that gives you access to justice. So we're going to talk about that. It's quite important in this area. Then we're going to look at quantum, settlement, mediation, things of that nature, because ultimately it often comes down in these cases to how much, rather than whether you've got a strong case. Then we're going to look at the costs issue and the fear that often punters have of often not necessarily their own lawyers' costs, but the cost exposure if they were to lose their claim. Then we're going to come on to choosing your lawyer and a little bit of advice and a little bit of a chat about the issues and what factors you need to consider when you're choosing your lawyer and choosing your firm. And then finally we will conclude, actually, and talk a little bit about what might be coming up next with these series of podcasts on what is a new website that we will have already just launched if you're listening to this podcast now. So, without further ado, let's just talk a little about head of claims. And when we last did a vlog, a video on the area of contested probate, we focused on, restricted the conversation to Inheritance Act claims. Now, I don't want to get bogged down in Inheritance Act claims, because I'll link it below, people can go and have a look at that video. But perhaps we could just say a little bit of why, in a way, it is important. I mean, I almost was going to call this podcast Inheritance Act claims before I realised it's actually contested probate, and it's a lot wider. And you said something interesting, Rich, when we were preparing this podcast about sort of the sense of natural justice in the area of Inheritance Act and how the Inheritance Act came about.
Okay, so a quick whistle-stop tour of the Inheritance Act. It was legislation that was passed all the way back in the 1970s, 1975. Its full name is the Inheritance Provision for Family Independence Act, 1975. Essentially, it has, we could break it up, if you like, into three layers. The first layer is who is able to make a claim under the Act, and it has specific categories of person. If you don't come into one of the categories, then you simply can't make a claim. The second, then, is what basis the remedy you should receive is, and there's different remedies depending on which of those categories you fall into. So the former spouse, for example, of a deceased person has a different level of claim in comparison with somebody else, like a child. And then the third is a list of other matters which the court has to take into account in order to decide how much of a claim you should receive. So they're the three things to look at, if you like. Who can make a claim? How much of the claim, should be based on what sort of person it is, and then what other matters should put the claim up or down.
Yeah, and the Inheritance Act itself is just set it in the context of heads of claim. I mean, don't know what you think about this analogy, Rich. I mean, please feel free to rubbish it. But often when I talk to clients, particularly litigants in person, I talk about the importance of knowing sort of through which gateway you're driving your claim. Because just to take a recent case that we've had of promissory estoppel, which is one potential gateway, so is Inheritance Act, simply one potential gateway created by a statute in the 70s. So you have got these various gateways of which the Inheritance Act is but one. I'm just trying to think what other gateways there are in the area of contested probate.
Yeah, sure. So another way of bringing a claim against somebody's estate is in relation to the validity of the will. So that's normally split into two subcategories. The first is if there's some sort of formal problem with the execution of the will. For example, if it's not been properly witnessed, or it doesn't use the right words to make it clear that it's a will, and so forth. And the second would be if the person lacked testamentary capacity. In other words, if they had some medical condition, or perhaps were suffering in terms of their mental capacity because of their age, and so weren't in a proper state to make a will. That's another head of claim. Promissory estoppel, I think you've already mentioned. There can be contentious probate issues in relation to the administration of an estate. For example, where beneficiaries feel that the administrators or the executors haven't legally followed the instructions and the rules that the will has set out. An example of that might be if executors were to sell an asset of the estate to a friend at an undervalue.
Oh, right. What head of claim would you bring in that instance then?
Well, it would be a breach of the executor's duty. So
So it's more like standard law, isn't it? Sort of like a bit like a breach of directors fiduciary duty or something like that.
Yes. So the will actually creates a trust where the beneficiaries of the will have a beneficial interest in the estate, and the executors are effectively trustees over that. So you've got a breach of trust claim if they fail to do as they ought.
And you've got undue influence as well. I guess that's not all that common, is it? I guess it's more like an Agatha Christie type Pimlico comedy situation, that, isn't it? Have you ever come across that? I've come across it in a recent case that I've got, but I'm not yet convinced that the evidence is there to support it.
Yeah, so I would shy away from undue influence cases. Normally undue influence is a term that's used in the context of contract law, where a person's entered into a contract but their arm has been twisted up their back. So I would say that it's quite rare in contentious probate cases. Yeah.
Yeah. So for our purposes, it's probably going to be pretty rare. I think it's quite important, especially for litigants in person. I have a case where, the claimant has felt particularly wronged, and you often find this with claimants. They feel particularly wronged, and they want to kind of like throw in the kitchen sink in terms of their pleading, the particulars of their claim. She did this. She was poisoned by my horrible siblings. She wasn't. She was a crazy person. There'll be a whole bunch of stuff, and there's a danger of bringing a claim that's loaded with heads of claim that actually for which there isn't the evidence.
Yes. So not all wills are drafted equally. So if you're in circumstances where the will that has been put together was done by a solicitor, then you've got a little bit of an uphill struggle to put together, for example, a claim that the testator, the person who made the will, lacked the capacity to do so. Because if they did, why did the solicitor sign off on it? On the other hand, if you've got a will that's been bought from the post office, a couple of the blanks on the form have been filled in and it's got a signature on the bottom, then you've got a much easier case to build. You don't need much evidence at all to challenge the idea that the person had testamentary capacity. And even if you can show, for example, that they were taking certain medication, which might affect their mental health, or that they were suffering from a condition which would affect their mental capacity, that might be enough to begin a challenge.
Yeah, no, yeah, well said. And I guess that the danger of bringing wrong heads of claim is that the other side, particularly, let's say they're executors who've got some money, perhaps they've even got some money out of the estate itself to fight off potential disgruntled claimants, they can make life difficult because they could bring a strikeout application. They could bring an application for you, that you've got to amend your claim because there's just simply no foundation for it, which could then be. It's a reality, isn't it, Rich? That costs are a big issue in civil litigation, and you could get yourself in hot water if you haven't properly brought a claim. I know it sounds a bit like an advertisement for lawyers, but I mean, even if you are a non-lawyer, fine. Be our guest, bring your own claim, but make sure that you have focused your claim.
Yes, quite often, in comparison with some other areas of law, which might be more dry or more commercial, a lot of people who come to contentious probate do so because they feel strongly that they've been wronged. Often it's an emotional place, as well as a sense of justice that feeling comes from. As a result, if a person in that situation doesn't get the help of a lawyer, doesn't get the help of somebody who's experienced and can give that independent view of the claim that's being filled in, some people can spend the claim form expressing their feelings as much as they are doing a legal argument. You did mention the costs of a defendant. So if the executors are defending the claim, then they will probably try to take money from the estate in order to pay their legal costs. There is now actually something that can be done about that. So executors face these proceedings effectively with two hats. At the one time, they're the executors of the estate. They're simply representing the deceased. But at the same time, they have another hat, which is that they are likely to also be beneficiaries of the estate. Now, one of the issues which is frequently fought over in these proceedings is to what extent they should be entitled to take money from the estate to pay their costs. Now, if they're acting fully as executors, then they're entitled to charge it all to the estate. But if they're really defending their own claim, their own share of the estate as beneficiaries, then they're not. And that can be very important. If you don't raise it, the court will probably just allow them to continue, and they then have a endless pot of money that they can use to fuel their litigation. If it's a matter that you do raise, you can get an order against them that prevents them taking money from the estate, and all of a sudden they've got to find the fuel to keep their litigation engine running.
It's really a critical thing, isn't it? A critical tactical thing. I do feel that in the area of contested probate, it is going to be hard for a lot of people without a lawyer. just because it's a complex area, it's chancery, it's often a multi-track case. There's certain protocols that you have to follow. and it's not put it this way, it's not a bog standard county court claim suing a shop for selling you a dodgy television, is it? It's rather more tricky than that. I mean, I've had a claim recently where the client did do a lot of the sort of pre-action, if you like, and post-issue as well, work, and he did a pretty good job, actually. We ended up on the wrong end of a strikeout application, interestingly, so note the earlier remark. Fortunately, the other side were a bit zealous, I think would be the word, in pursuing the strikeout application, and they lost. I mean, it was such a small failing by a litigant in person that the judge actually made a cost order against them, didn't he? So I guess you've got to be. Anyway, he kind of got away with it. It could have been a hot water situation, that situation. And what you had is a litigant in person taking it a long way, not just pre-action, but actually issuing proceedings himself. Well, credit to him, it was quite an impressive feat, really.
Yes, I think the one you're referring to was one that I did the advocacy on a few weeks ago. What was interesting, when we won, we walked out of the court. My client was very happy. He knew that we'd won, and so he was delighted with the outcome. But the telling thing was that he didn't know why we'd won, because he hadn't understood what had happened in the courtroom. He didn't understand how the judge had reasoned to the conclusion that he had. And that really shows that the argument that won the day was not an argument that he could have ever made, because it was too technical, too legal in that sense, too legalistic. Yeah,
he was flying close to the wind, but he got away with it and sort of instructed solicitors just in time, I guess. That brings us on to the issue of settlement, quantum mediation, things of this nature. Basically, as often as not in these cases, claimants will probably have an unrealistic idea of how much money that they're entitled to, but they probably will be entitled to something. I mean, just off the bat, how many cases have we had where we completely failed to get anything for our clients?
Well, it's pretty much unheard of. The reason for that is because most contentious probate claims are not win-lose claims, and what I mean by that is that they are very likely to result in a negotiated settlement. In order to explain this to clients, I often say that they're similar to a divorce. When a spouse claims against their former spouse in divorce proceedings, it's not clear whether they'll get 40% of the money or 50% of the money or 60%, but they'll get something. And the purpose of the litigation is to decide how much that should be. So in circumstances where somebody does have a good claim, it's normally not about are they going to win or lose at the final hearing. Instead, it's about how much is that claim really worth and how do we negotiate to the right settlement figure.
Yeah, and I guess that's obviously where mediation is probably quite more commonplace in these areas than anything else, than any other area, because the defendant kind of has to accept and deep down knows that they're going to have to part with something. It's just a case of negotiating the best settlement for the parties, and of course, particularly in these areas, the lawyers' fees are eating up the estate the closer you get to trial, aren't they?
Yes, and so
sorry to interrupt, but you had a case about a year ago, didn't you, where that was there wasn't much on the table and it was in danger of being entirely eaten up.
Yeah, so that was a case that I remember well because of the very stern advice that the judge gave directly to the clients at one of the hearings. So we'd conducted the hearing already, we'd agreed to do mediation, we'd agreed how many witness statements needed to be done, what disclosure needed to be made, and indeed, if no settlement was reached at mediation, how long the trial would be and what the timescale for the trial was. And then at the conclusion of the hearing, the judge said, I'm not talking to the lawyers anymore, I'm talking directly to you. And he
actually looked them in the eyeballed them both.
Yeah, he said to the lawyers, "I'm not speaking to you anymore. I'm speaking to," and he named the people, and he said that he understood that they were they had ill will against one another, that they'd fallen out. But he said, if they could not reach a settlement, then they would lose all of the money. He said, if you continue to fight, all the money will go into the pockets of these lawyers here, and there will be nothing left for either of you. So he said, I appeal to you to put aside the ill will that you have and to reach some sort of settlement before these lawyers rob you any further.
And that was a case in which you had a partner of the deceased who wasn't kind of accepted and hadn't been fully embraced by the family and other siblings.
Yeah, so it's a bit of a cliche, really. There's a few cliches that lead to these Inheritance Act claims. One of them is that a chap has children by his first marriage, then he either divorces or for some reason perhaps his wife passes away, and when he meets a new partner and remarries, the new second wife is younger, and the children of his first marriage have grown up, so they're young adults, and perhaps the age difference between his own children and the new partner is not that great. And so you find a sort of tension or bad feeling between the children and the new wife. Perhaps they don't get along very well. Then when he passes away and they discover that there's nothing for them, it's all going to the new wife, and that can be the case, for example, where there's no will at all, depending on the size of the estate. Both sides are feeling very litigious. They're feeling hurt, they're ready to go to court and have a big scrap together. So you sometimes find that these sort of cliched family conflicts are the things that give rise to contentious probate cases.
Yeah, okay, that's a good point, and hence the judge kind of saw that, probably handled these types of cases before. That we could touch quite quickly, I think, there, following up on what we've just been discussing, on the area of costs, and in particular the fear of not even beginning a claim. I mean, no one wants to fall out over wills, and obviously you only come to a lawyer once you've exhausted all other options. But often as not, people don't take notice unless you actually issue proceedings in court.
I think the first thing that I want to say here is that there are extremely tight deadlines on bringing an Inheritance Act claim, and that...
Well, and is that the same with other contested probate types of claims?
It depends. So I'll speak a little bit of the specifics, but really the thing that people should take away is just to take advice as soon as possible, rather than trying to work out themselves when the deadline is and sailing right up to it. I have had the experience of having to work all night in order to get a claim in before the deadline, and it's not one that I enjoy.
And it's probably not a bill that your client enjoyed either.
No, that's true. They do have to open their wallets to convince me that I want to stay up all night to do an emergency application for them.
I thought you were just sort of a philanthropic lawyer.
Yeah, sometimes I am. The basic deadline for an Inheritance Act claim is 6 months from the date that probate is taken out. So the reason that's the case is because once the executors have administered the estate, that is, they've sold the assets, paid the liabilities, and then distributed it amongst the beneficiaries, if you then bring an Inheritance Act claim, then it's too late. The money's gone. It's been handed over.
Okay. So you've got to make sure to get your foot in the door before the probate door is actually closed. But that presumably that goes whether you're bringing a claim for undue influence, lack of knowledge, lack of testamentary capacity, promissory estoppel, whatever.
Well, I would say in those circumstances it's worse. So really what you want to do there is to prevent the grant of probate being taken out at all, never mind bringing it within 6 months of it having been granted. So there's a special procedure called lodging a caveat. So what you do is you make an application to the court which says, I am unhappy about the probate of XYZ person being granted. Then when for example, you don't think the will's right, or you think it's the wrong will, or you don't think the executors should have the right, perhaps one's bankrupt, or something like that. So what you do is you make an application to the court and you say, if anyone makes an application for probate, come and tell me and give me the chance to dispute it. So what that does is it creates a window in which any application for probate can be stopped and then brought before the court, so the court can decide who should properly administer the estate, who should be the executors. So really the advice there is, if there's some uncertainty over should it be this will or that will, or is this person acceptable as an executor, or are they not acceptable, etc., etc., you need to get a caveat registered as soon as possible. Do it yourself or go and speak with a lawyer.
And actually, if you really can't afford it, do it yourself. And the recent case that we've had, he did it himself, and at the moment he's fine. The bigger issue there was, it remains to be seen whether or not the statement of case, the pleadings, are overloaded with too many heads of claim. So I think we don't really need to talk much about the danger of costs. I mean, in lots of litigation, there's this big, particularly post the no-win, no-fee reforms, whereby you can't recover your insurance premium from your opponent, even if you win. People may have this fear that, oh my God, I'm not going to bring a claim. I had this actually, and that actually they went away. This was the couple in Essex, and she had a claim and seemed like a pretty decent one, but they were worried about having to pay their opponent's legal costs if they lost. And it was just, they couldn't be convinced. But I think probably what you're saying is that you don't kind of need to be too worried about that. Is that true? Are there any circumstances where you do need to be worried about your opponent's costs?
Yeah, absolutely. So I think really the issue is about confronting the situation and finding out what the reality is, rather than being controlled by your anxiety. I guess as a metaphor, I would relate, it's like if you've got a lottery ticket and you don't want to check what the numbers are. You don't want to see if the lottery ticket's worth nothing and you should throw it away, or if the lottery ticket is a winner and you can go and claim. But of course, in the circumstances of an inheritance claim, it's worth nothing if you don't check. Another way of looking at it as a negative would be if there's something wrong with you in terms of your health, but you don't want to go to the doctors to find out whether it's a serious illness. Well, again, if you allow your anxiety to control you, then that illness is only going to get worse and worse. You're not going to get the treatment that you need. So in these situations, you may have a claim, you may have a legal problem, you may have a legal opportunity, you don't know. By facing into it, getting the information, getting informed, getting advice, you're then much better placed to make a decision about whether or not you want to proceed.
Yeah. Have we had cost orders against us in any of our contested probate cases?
No, I've never had a cost order against any of my clients.
And I'm yet to either, touch wood. It's a bigger fear, isn't it? It's a monster in your own mind, but really it's a pygmy in reality.
Yes, I think the only time where we would be in circumstances where we'd be at serious risk of a contentious probate adverse costs order would be where I was saying to my client, look, I don't think this is a very good case, I don't think we should proceed. And they were saying, okay, Richard, I've heard that advice, but I want to proceed anyway. Here's the money, I want to pay your bill, I want to be aggressive even if it's against your advice. Now, that would be when we were at risk of having an adverse costs order. But I've never been in that situation.
Or where you've got an offer on the table and the client doesn't want it and they want to go for more against your advice.
Yes, and they can be quite difficult conversations to have. Of course, we all want our clients to do well in litigation. We're optimistic for them. But sometimes you've got to give that hard-nosed, commercial, independent advice. Look, the offer on the table's good. Let's settle. Let's draw a line under it.
You had a difficult telephone conversation not so long ago, where you were confronted with the situation of having to eyeball your clients and tell them the hard truth.
Yeah, sometimes. Yeah, I've had that situation on more than one occasion. I think I know which one you're thinking of. It's really just a question of managing their expectations. I mean, that's in the end, that's what they're paying you for. If they knew how good their claim was, if they knew how to conduct litigation in court, if they were experienced in speaking to judges, they wouldn't pay you, they'd do it themselves. Yeah. The same when you have a problem with your car, you go to the garage to get a car mechanic to fix it. It's the same thing, and you're not doing your client any favours if you sugarcoat it or you hide the truth because you want them to feel good or be pleased. You're doing the best you can when you give the most accurate, truthful advice that you can possibly do.
Yeah, that's perfect. Yeah, I have to say, I like your use of metaphors and analogies in this podcast. That's spot on. Yeah. Must be because you're a northerner. You've got this way of talking the straight truth with similes, metaphors, and analogies. I'm a fluffy southerner. I go on forever. Right. Anyway, so let's bring things to a conclusion. Before we finally wrap up, it's the final section, which kind of relates to this section of your opponent's cost, the risk of having to pay your opponent's legal ability to lose, is your own lawyer's costs. And in this instance, really, the overarching question, I think, and it's a big issue for the public. It is a big issue because it's an area which they know, as you say, very little. How do you go about choosing your lawyer? And but before I give you the mic, Rich, my kind of view so far is that you obviously need to find a good lawyer, and they mustn't just be non-contentious. They must have litigation experience. But also, there's the issue of the firm, because perhaps this is me, because I'm skewed, because I've done a lot of no-win, no-fee litigation in my career. So I'm genuinely interested to hear your thoughts on this, actually. So that is something I think that it's absolutely essential that you might find a good lawyer, but the firm for whom they work, the structure of the firm in which they operate, doesn't allow a wide variety of retainers. And obviously the classic example of that would be where a lot of law firms are very conservative. They do not like the idea of having to cash flow litigation, and they do not like no-win, no-fee, period. So even if you've got the top litigation lawyer, his firm may not be interested in no-win, no-fee litigation.
Yeah, so I would say...
We've certainly chosen the spot, haven't we? I'll get that section out.
Okay. Yeah, so I would say that a bit of common sense advice in relation to choosing a lawyer would be as follows. First of all, if you can look at that lawyer's experience and expertise, that's obviously going to help. Is this someone who's just done one or two inheritance claims ever, or is this somebody who week in, week out has been doing contentious probate for months and years? That would be the first thing. Second of all, I think if you can get a personal recommendation, if you can talk to a happy customer, if you like, then that can give you some insight in terms of the strengths and weaknesses of any particular lawyer, what they're like. And third of all, I think nothing really can replace getting in touch and having a chat with them. Is it somebody that you get along with? Can you communicate well? Do you feel that they listen to you, take on board what you're saying? Or do you find them a bit distant, difficult to communicate with? Do they use a lot of legal jargon, don't explain things very well? I suppose one final factor is to be a little bit careful over the costing. A red flag that I would raise there is that I've seen some cases where I hasten to add that have been dealt with by other lawyers, where I feel like the case was never really going anywhere, and that was probably obvious to the lawyer, but they were just sort of milking it for as much money as they could in the meantime before dropping it. So yes, I've certainly seen that. Yes, I'm thinking of a matter, for example, that you ended up taking over from other solicitors in London. It wasn't a contentious probate matter, but it was another type of commercial civil litigation in relation to multiple companies, where I felt that the former solicitors who'd handled it had charged a lot of money and not really moved the case very far forwards.
And you know what? There's a danger of that in a contested probate claim, isn't there? But because both lawyers almost like wink and a nod. We know there's a huge pile of money in the estate. Let's trundle this litigation along. Let's take it halfway or 3/4 of the way towards trial. Let's milk it a bit before we come to a settlement. Do you think that happens?
Well, I don't like to cast aspersions upon my fellow lawyers. I'd like to give them the benefit of the doubt where I can. However, what I would say is, when you instruct a lawyer, it becomes quite difficult. It becomes costly to change lawyers down the road, and I think it makes sense to think carefully about who you pick to work with, who you choose to represent you in what will be a matter that will perhaps dominate your life. It may become the thing you think about at night before you go to sleep, the thing you're thinking about in the morning when you wake up. And you really do need a solicitor who you feel happy with, that you trust, that you feel is representing your best interests, that has the appropriate competence to properly prosecute your case for you.
And what do you think of the point that there's a danger at the structure of some law firms? I've had experience of this in the odd personal injury claim I've done once or twice, where you kind of feel that the firm is just turning the handle, and they are not really 110% invested in the claim. And I mean, what do you have to say about whether no win, no fee retainers are appropriate in this particular area of law?
Yes, they can be appropriate. So I would say that lawyers will be quite cautious into when they're considering whether or not to enter into a no win, no fee or a partial conditional fee agreement, where perhaps they'll want some of their money as they go along, but they'll be willing to wait for a proportion of their money down the road. I would say in some sense it's a question of the lawyer putting their money where their mouth is. If you've got a lawyer who tells you that your case is the strongest that they've ever seen, but at the same time they're not willing to postpone a penny, they want paying up front each month, then it's hard to see a coherence between those two things. They seem contradictory. So when you have got a solicitor who says, look, this case is great, it's extremely strong, I see no risk of adverse costs, I think you're going to win X £1,000.
And then you ask them, okay, in that case, are you prepared to look at a no-win, no-fee retainer?
Yeah.
And sorry to interrupt, but just like the estate might be quite large, so their 25% or whatever it is going to be a substantial sum, calculated risk.
Yeah. If they won't agree to that, they won't offer it, then you have to ask yourself the question, why? And as I say, it's really a matter of lawyers' willingness to put their money where their mouth is.
Yeah, I like that. And there are hybrids now, reduced no-win, no-fee, where you charge the lawyer half and he takes a smaller percentage. We've got one, haven't we?
Yes, and at the same time, there are other commercial factors. It's not only about the case. Some law firms might not be in a position where they can offer a conditional fee agreement. If a small firm runs 10 cases at a time and it's already got 9 as conditional fee agreements, they might take 6 months or 12 months or 18 months to run their course. Well, at the end of the month...
How are they going to pay the salaries?
Yeah, at the end of the month, the lawyer needs to keep the lights on, needs to pay his rent, needs to pay his secretary, and so on. So there are some commercial factors for solicitors, but when you're dealing with a huge firm, a very big firm with multiple departments, then it would be hard to understand circumstances where they wouldn't even consider a conditional fee agreement if they're telling you the case is unstoppable.
Yeah, I quite like your point earlier about suck it and see. I mean, there's no reason why you can't, particularly if you're looking at a $500,000 estate, a big contested probate claim, why you can't instruct a solicitor to do a preliminary advice or something, bung £500 his way, get him to look at the papers, you get some value out of him, and if you like him, you can continue. If not, you can go somewhere else. And there are a lot of sort of unbundled retainers, is that the word? A lot of small scale limited retainers where you can get quite easily some advice. It's not going to cost you an arm and a leg.
Yes, that makes a lot of sense, and it makes a lot of sense from a financial or commercial point of view. If your downside is that you have to pay the lawyer £500, but your upside is that you've got a claim against a £500,000 estate, then if your chances are 50%, if they're better than 50%, even if they're low, even if they're only 25% or 10%, the figures still stack up. It makes sense to pay a little bit of money to see whether or not your lottery ticket is a winning ticket, if that makes sense.
And 500 and 1,000, you're even 1,000, or I think 3,000 in the big estate we've got, where we've asked for money to give a proper comprehensive review on the case and advise on the next steps. So thank you for that, Rich. I hope that's been valuable. We hope to produce many more podcasts and vlogs on this area and on other areas. I quite like the idea of podcasts going forward that, actually building up a library of different types of cases, like a suite of promissory estoppel cases, some inheritance cases, some of ours that we've done and historical, or some case, actual case studies of case law. Case law is obviously highly relevant in this area. So, that's one area in which I think we can help. And I think another area which I'd quite like to look at is actually helping people with sort of like the mediation, the pre-action stage. I mean, I had a client recently, not in a contested probate case, but in a cohabitation property dispute, where feelings are running very high, and he had actually already had an advice from a barrister, kind of like a year or two ago, that his case was weak. And yet he was so angry about the split. And there was a sort of an ethical and a moral injustice, but it was clear to me that he was unable to move on with his life. And I actually gave him some advice, and then he sort of said, well, I still want to sue. I was like, oh, okay, well, that's my advice, but if you are going to sue in this way, and I prescribed this way in which I suggest you brought a claim. He then wrote a 12-page particulars of claim, running his own case. No, it wasn't a particulars of claim. It was a reply to a defence that's as often as not unnecessary anyway. And anyway, I ended up saying, look, let's meet for a drink. And we sat down in a bar in the Baltic in London. And he wasn't I thought he might be a bit unhinged. But he wasn't. He was just a regular guy who had a lot of potential, fallen on hard times, wheels had come off a relationship, it had affected his career, his life, and he'd let it become a big issue. And really, we just had a couple of hours drinks and a bite of dinner together, and I was really just saying to, after I'd given him the legal advice, it was just like saying, look, mate, you need to get over this and find a way of drop it and get on with your life, put your energies into a fresh direction. So I think I'd also be interested in future podcasts and just perhaps looking at the human element and how to deal. Sounds a bit touchy-feely, doesn't it? But I think people do need help, guidance and counselling almost, alongside, seriously, a heavy, wet, emotional issues like inheritance. Do you ever feel that you're a bit of a counsellor or a psychiatrist or vicar when you're?
Sometimes. So I mean, I do have a box of tissues in my office.
Yeah. You were a family lawyer for a while, weren't you?
Yes, I've had the odd tear come out of clients whilst I've been interviewing them. But I think that there's an emotional background to all litigation, and it's not just the clients; it's the lawyers as well. Sometimes one lawyer offends another lawyer, and then you end up with this very sort of entrenched, vengeful vein running through litigation.
Yeah, we've had that in a case recently, haven't we?
Yeah, that can happen. So lawyers, just like clients, are human beings. Might be hard to believe, but it's true. And so I think it's always important, if litigation is going to be successful, for people to understand the emotional background to it, to understand what's driving the litigation on that level, so that they can continue to try to make the best decisions they possibly can.
Yeah, try and keep a clear head. And we often, our judgment can get clouded as lawyers too. We can get extremely close to a case if it's going on for too long. That's where I find barristers are particularly helpful. Although, the public often think, why have I got to pay for a solicitor and a barrister? Aren't they both lawyers? But I think that's, and for example, we have weekly meetings where we discuss our cases, don't we? And you throw a sense of perspective on issues. I think that's equally important. All right, well, I think we've probably exhausted you. If you're still listening to this, haven't drifted off, and I think we're probably about to. We've had a long day. We've been on a jolly out into the countryside. We just got back this afternoon. So there it is. Stay tuned. Hope you've enjoyed the inaugural podcast of the Contested Probate website. Should go up on the website and on the YouTube channel. And I will link, but in the description box below, all the relevant website addresses and the YouTube channel and any other related links. So check the description box below. If you want to get in touch with us, info@redwoodlegal.co.uk. It's immensely helpful. I sound like a crack record, but it's just so helpful if you email us all the relevant documents as a PDF if you can, and a short email just telling us the story and giving us a number where we can contact you so that we can kind of quote you for the work, as well as get an idea of the case and whether it falls into our area of expertise.
Yeah, thank you very much, Alex. Appreciate the conversation, and good luck to our listeners, whether you're pursuing a case off your own back or seeking legal advice, whether you contact us or another lawyer. Good luck. I hope you get the right result and you're able to put to bed these issues, which I know can be very difficult for people.
Yeah. Keep a clear head, folks. Bye for now.